Warm welcome. Right. I'm Sophia Meyer-Hill, and we're going to go ahead and get started. Thank you again, Sharon. Next slide. So this presentation is really about, your child's been suspended, so now what? So we're going to talk kind of about the legal framework for protecting kids and kids with disabilities in the event of an exclusion from school, particularly a disciplinary related exclusion. Next slide, please.
Let me interrupt for just a moment, Sophia. It's showing us the presenter view and not the slideshow.
Great. Ashley, can you make that adjustment? While Ashley is making that adjustment. Okay, great. Thanks. All right. Next slide, please. So as we already kind of got a little bit of an introduction, I'm Sophia Hill. I'm an attorney with SPLC. I'm joined by my colleagues, Ashley and Lauren, who are also attorneys at SPLC. And we are with the Children's Rights Practice Group. So our work really focuses on the rights of children, but primarily school-age children. So we do a lot of work K through 12. Just as a couple of disclaimers, we are attorneys, but there is no attorney-client relationship between us and anyone attending today. So we will do our best to keep everything that is asked confidential, but we do ask that you not share. If you have specific questions about cases you're working or families you're working with, we ask that you not share any, identifying information about them or any details. If you have specific questions that you're working with families and would like to speak with us, we are happy to arrange that kind of on a separate call and offline. So just wanted to add that disclaimer. And now we would love to hear from you guys. So, it's really important to us that we do our best to cater the presentation to what's useful to you all. So we'd love to know a little bit more about who's in the room and what you'd like to learn. So I'm happy to turn it over and we can just kind of popcorn it. I can just cold call on somebody like it's a school. So I see Laura Nada. Refresh. Okay. And happy to have folks drop it in the chat as well. Okay.
Hi, I'm Rochelle McMahon. I am a grandmother. I have custody of my grandchildren, and one of my granddaughters is diagnosed with sensory ADHD, autism, other health impairments, and we were having issues on the bus, and we had to pick her up last year from school. She do have a 504 plan, and we're working on trying to switch over to an IEP so that she can get some services. And I hope to learn, can she be suspended? Why were we told to come pick her up? What is our protection for her? And how can we advocate to keep her in school so she does not lose any of her academic hours of learning?
Great. Very helpful. Thank you for sharing that.
I am Yardina Stevens Wilson, and I am a school counselor. And I'm here just to learn more rights that I have for my parents so that I can share that information with them.
All right. Well, if anybody else would like to share kind of who they are and what they're hoping to get out of this presentation, feel free to drop that in the chat. And we'll do our best to kind of course correct throughout the presentation if there's areas we think we kind of need to explore based on the participants. So appreciate everybody offering that up. So just as a reminder, SPLC is a legal organization. We have a new mission statement from the last couple of years. So we are a catalyst for racial justice in the South, working in partnership with communities to dismantle white supremacy, strengthen intersectional movements, and advance human rights. Like I said, Lauren, Ashley, and I are part of the Children's Rights Group, and we really focus on 3 areas within that realm. So we work a lot on education equity, and a lot of that work actually goes into special education and the rights of students with disabilities to have a FAPE. We also do work around dismantling the school to prison pipeline. So really this discipline and exclusionary process that we're so fighting against. And the third piece is advocating for expanded access to mental health services for kids and families. So those 3 areas keep us pretty busy, but all of it within the greater context of SPLC. And I did just want to note, because I heard somebody say that they're with a school district. If you are with a school district, please just exercise caution, because we do have active litigation involving a number of school districts, especially one in particular, NOLA PS. So if you are with NOLA PS, I would, we're glad you're here, but you do have private counsel. And so I would just, direct you to them if you have specific questions about our presentation, or if you'd like to get in touch with us, we would encourage you to go through counsel and not reach out directly to us. All right. Next slide, thank you. So this first slide is kind of the lay of the land. So these are the discipline laws that govern pretty much most students, all students, I should say. So this is the lay of the land. Louisiana Revised Statute section 17416 is your bread and butter discipline statute for all students. It goes through the ways in which students can be suspended and expelled, talks about weapons, talks about returning to school, the length of a stay, and really what's required before a school can act. It is very detailed. I personally don't think it's very well written. So it may take a couple read throughs to really understand what is getting at it. And we often see schools misapply this. And so it's always a good reminder to go reread the statute if your child is facing discipline. The other 2 options are Bulletin 741 and the handbooks. So Bulletin 741 governs disciplining of students with disabilities in Louisiana. And then of course your handbooks, or your school handbooks, provide additional insight into when a child can be disciplined. I will say that there are a couple of courts, I've looked at this recently, a couple of courts in Louisiana that have found handbooks to be a contract between the child, family, and the school district. So you should always look to, if your child is facing discipline, to confirm that the discipline or the infraction is a proper application of the school handbook. So just something to always keep in mind as well, an additional source of law for you. Next slide, please. So then the big question comes up. We're curious, when can schools discipline students? A question mark is a question for the group is, can students be disciplined for violations of the school rules in the handbook? What about violations of school rules on the school bus? How about a school football game, or after campus or after school activity on campus? And then what about off campus? A social media post made about your child, made by your child, made at home. What do folks think? Can a child be disciplined for one of these, all of these, none of these? What do you guys think? Just drop it in the chat. People say most of these. Anything else? So yes, people think yes. So the first one, can a school handbook violation? Yes, schools can discipline students for a student handbook violation. School rules on the school bus? Also yes. Football game at school? Also yes. The social media post made by your child at home, that one's a bit trickier, as some people said in the chat. It's a little bit nuanced. There was a recent Supreme Court case, you may have heard about this, involving a cheerleader who after school made posts about, unbecoming posts about the coach. And she was not able to be disciplined after the Supreme Court ruled. So it's a nuanced conversation, but there are some definite, yes, the school can discipline a student, and some murkier areas. Moving on to the next slide. So when we're talking about discipline, I think it's important to remember that there's a lot of different kinds of discipline, and you should also keep this list kind of in your arsenal as alternatives if your child is facing a suspension or expulsion. So there are always ways to hold children accountable for their behavior, and we want to encourage that. We just want to make sure that the accountability measure is proportional to the child's, age and needs. So reprimands and counseling are always options and should be your first line of defense. There are after school sessions and Saturday sessions, detentions, school bus and activity bans. We don't really like that because school bus bans are a barrier to attendance, but it is also an option. And then of course, you can get to suspensions and expulsions, both in school and out of school suspensions. But where suspensions and expulsions are occurring, the law requires that the school follow due process. And due process is a legal term of art, but it really means procedure and process that they have to go through before they can exclude a child. And then of course, schools have in the past resorted to seclusion or physical restraint, especially for kids with disabilities, but seclusion and physical restraint should never be a way to hold a child with a disability accountable for the behavior. It should really be only for safety of the child and others. And parents should be notified as soon as possible if that does occur, but it should never be kind of the go-to. It's an exception. Okay, next. So what is due process? Like I said, it's a legal term of art, and a lot of the due process rights that are newer to students came out of a 1973 case called Goss v. Lopez, which was the first time the Supreme Court really looked at what must a school do before excluding a child. So when we talk about it, it requires at a minimum, students have to receive notice of the charges filed against them or the charges levied against them. I shouldn't say filed because not always criminal, but of the charges levied against them and an opportunity to be heard before they are suspended. And if a child is suspended for 10 days or more, then they have additional rights, like a formal hearing with their parent present. They can bring an advocate or an attorney, and then there's appeal rights as well. But when we're talking about suspensions or exclusions for 10 days or less, they still must be given notice, and it can be oral, but we would always encourage folks to advocate that it be written, and then an opportunity to tell their side of what happens. Again, though, if it's 10 days or more, you get more process or more proceedings. Example would be written notice, statement of evidence, date, time, and place for a hearing, and a right to representation. And again, this is just for clarification, this is for all students, regardless if the child has an IEP or 504 or even has a suspected disability. So this right would apply to every child. Next slide. Okay, I'll pass it over to Lauren.
Thanks, Sophia. And I'm going to talk about suspensions and expulsions and what they are. And again, that is for all kids. So, and we'll get into differences for students with disabilities a little later, but we'll start off with suspensions. So what is a suspension? You can go to the next slide. So there are generally two types of suspensions that our state recognizes: out of school and in school. Out of school, of course, is a removal from of the student from all classes and the public school grounds, and usually they're unable to attend any other school sponsored events. So that's when the child's usually sent home. And then an in-school suspension is taking the child out of their normal classroom setting, and usually there's an in-school suspension class or a separate classroom that they attend for the duration of their suspension. Go to the next slide. Okay, so this kind of came up earlier. What happens if the school calls you and tells you that you have to come pick up your child immediately? They do not say that it's a suspension, and you never get notice of any kind. Has your child been suspended? What do y'all think? You can put it in the chat, yes or no. a few different answers. Okay. You can go ahead to the next slide. So most people are saying, no, this is not a suspension, but it is a suspension. This happens quite a lot actually too. I'm sure you're aware that the school sends a child home early or, early in the day for disciplinary purposes, or they're asked not to return to school for the rest of the week or something like that. That is a suspension. A lot of schools do not, there may be different reasons for why schools do not go through the formal process of actually documenting this, but if it's not, documented, then they don't have to report it to the state. So it sometimes keeps numbers down. So what you can do is ask for documentation from the school, create your own documentation, or contact the school district that the school is under. You can also ask for legal help. So one thing that I see advocates and families do is, in terms of documentation, is to just, what's nice is email, and just emailing the principal or whoever at the school would be appropriate, and just like explaining what happened from your point of view and all of that. Then you have the time and date and what happened, and you kind of keep a paper trail for yourself. And then that puts the school on notice. All right, next slide. So whether your child is suspended and officially, and you get the notice and everything, or in this other way, that sometimes we call ghost suspensions or silent suspensions, where you don't have a record of it from the school. Either way, your child still has a right to know why they're being suspended and an opportunity to explain their side of the story, like Sophia was talking about. So you have to receive notice of the reasons for suspension and the date and time for a conference with the principal. You must receive the notice in writing of the suspension and the reasons for the suspension in your language. So whether that's English or a different language, a school does have to send that notice in the appropriate language for the family at home. Your child must have their schoolwork sent home during this time. And from the date of the notice, you have 5 calendar days to appeal to the superintendent of the school district. It's a very short period of time, and it is 5 calendar days. So that's including weekends and everything. So it's a very quick timeline. Go to the next slide. This is just a reminder that if this happens, you must attend the suspension conference with the principal within 5 days of being contacted. Otherwise, your child could be found truant or prevented from returning to school. So if you get that notice and it sets out the meeting with the principal, be sure to respond and set up that suspension conference with the principal or whoever is meeting with you. All right. Next, we're going to talk about expulsions generally. What is an expulsion? In Louisiana, that's a removal from all regular school settings for a period of not less than 1 school semester. So it has to be a situation where a child is told, you have to leave school for a semester or more. There are lots of reasons in the Louisiana state law why a child could be expelled. Usually there are some automatic situations for severe actions, like having a gun at school or having drugs. So it varies, but there is also a required placement in an alternative school or in an alternative educational placement in Louisiana. So generally, kids are not just sent home and, for a semester doing nothing. There is this requirement that they be placed in an alternative setting of some kind. Next slide. All right, another quiz time. The school sends home a notice stating that your child is suspended for the rest of the school year and that during that time, they will be required to attend a disciplinary placement at an alternative school. Is this an expulsion? And you can go ahead and drop your answers in the chat. And most people are, we have a couple of yeses, we have a no. All right, you can go ahead to the next slide. The answer is maybe. This could be an expulsion. If the school sends your child to an alternative school for longer than a school semester, then they've been removed from school under, or quote, not less than one school semester. That is the wording under the law. So again, you can create your own documentation. You can consider filing for due process if the child in this case has a disability. And of course, you can contact the school district leadership at the district level or seek legal help. So it mostly depends on how long the time period is for the removal from school. All right. So what happens if your child is expelled? You again must receive notice of the recommended expulsion in your language, including the reasons for the expulsion, and then the date, time, place of the hearing that is set to take place. The student will be suspended until the time of the hearing. And then after the hearing, depending on what happens, you can appeal the decision from that hearing before the superintendent. You can appeal it to the school board within 5 days of the decision. And then after that to the district court or the parish within 10 days of the school board's decision. So there are a couple of more layers to an expulsion and decision and how you can appeal it throughout through the process. All right, and I'm going to turn it over to Ashley, who's going to talk about MDRs and students with disabilities and how these laws impact them.
Thanks, Lauren. So now we're going to talk about the additional protections that apply for students with disabilities who are facing school discipline. So the most important thing to remember, which you all probably know, is that students with disabilities have more protections from suspension and expulsions than other children who do not have disabilities. They don't have less protections. And this includes all children with disabilities, and that means students on IEPs, 504 plans, and also students with a suspected disability, for example, students in the process of an eligibility evaluation for an IEP or 504 plan. If the school has a reason to know the child has a disability, then the same procedural protections apply under the Individuals with Disabilities Education Act or the IDEA. And these protections kick in after your child is out of school for 10 days. And that's 10 days consecutively or cumulatively as part of a pattern of behavior. So 10 days total within a school year. Up to 10 days, your child with a disability can be disciplined like any other child, but after you hit that 10-day mark, your child gets additional legal protections because absence from school for this long is considered a change of the school placement. And the term placement is a legal term of art within the Individuals with Disabilities Education Act. And students with disabilities under the IDEA cannot have their placement changed without a meeting called a manifestation determination review meeting to determine whether the behavior that they're being disciplined for was the result of their disability. So let's talk about the manifestation determination review meeting. At that meeting, one of the most important things we'll cover is that you do not have to discuss whether the behavior the child is being accused of actually happened. rather the meeting is to address whether the behavior occurred in some way because of the student's disability. And just like with an IEP team meeting, you have to be invited to this meeting in writing, and you have a right to attend. And if the MDR meeting doesn't go the way that you want, you have the ability to appeal that MDR decision by filing a request for due process. And this request for due process will be expedited, meaning it's heard very quickly by a state administrative hearing officer. And you can actually file that within a year of the MDR meeting, where you disagreed with the result and they excluded your child from school. So these are the two questions, and the only two questions that are relevant during that MDR meeting. The first one is, was the behavior that your child's being disciplined for caused by, or did it have a direct and substantial relationship to the student's disability? And the second question is, was the conduct a direct result of the school's failure to implement the student's IEP? And these are the two questions that are laid out under the federal statute, the IDEA, as the only questions that are relevant during a manifestation determination review meeting. And basically the key question is whether the behavior occurred because of your child's disability. So here's a graphic that will be available to you after the presentation through a guide we have on SPLC's website that kind of guides you through what will happen based on different results in an MDR meeting. So if the team determines yes, in response to the questions that were on the last slide, the behavior was related to your child's disability, then the school district cannot suspend or expel the child. And the school will also have to conduct a functional behavioral assessment and or update the child's behavior intervention plan or IEP. And this is the reason why your MDR meeting generally should come before any suspension hearing or expulsion hearing. There's no need for a suspension or expulsion hearing if the child cannot be suspended or expelled for the alleged behavior. Some other things that can happen, which are noted on this slide, are that the MDR team can determine that yes, the alleged conduct was caused by the child's disability. In other words, the answer to the first question is yes, but the school can still remove the child to an interim alternative educational setting for 45 school days. So this is not a suspension or an expulsion. It's a removal to an alternative placement, even though the student, the behavior the student is accused of was related to their disability. What's important to note is that the school can only do this in very limited situations. And sometimes we see schools sort of going beyond these very limited exceptions where an alternative setting is appropriate, even though the behavior is related to the child's disability. And that includes situations where a child is carrying a weapon, knowingly uses, sells, or solicits drugs, or inflicts serious bodily injury. So it sometimes is important to go back to the IDEA to remind the school of what these limited exceptions are in the event they want to remove your child to an alternative educational setting, even though everyone in the MDR meeting agrees that the behavior was caused by the child's disability. Alternatively, you and the school district can agree to an alternative placement for the child at any time, but we're going to talk more about this in a minute. And of course, if the answer to the two questions on the last slide is no, there really wasn't a relationship between the child's disability and the behavior that they're accused of, then they can be disciplined like any other child, and you'll proceed to the suspension or the expulsion hearing that Lauren walked us through earlier. So let's talk about some tips for getting through these MDR meetings. They can be really hard. One thing that can really help is to keep the school focused on the two questions we discussed earlier. one, whether the behavior had a direct and substantial relationship to the child's disability or was caused by the child's disability, or two, whether the behavior was the result of the school district's failure to implement the IEP. Whether the child's behavior was right or wrong is irrelevant. It's not one of the questions in the IDEA, and you can remind the school district that it's not the time or place to be having that discussion. In addition, it's not even the time or place to be having a discussion about whether the alleged behavior occurred. Something we want everyone to be aware of is that, you know, Louisiana is a one-way recording state, so it's possible that an MDR could be recorded, and we have heard that in some districts they sometimes are. So if there's a chance that your child could face criminal consequences for the behavior they're accused of, then you do not want to be admitting that they did that behavior in a recorded setting. So we encourage parents to use if statements. So for example, if my child did this, then it was the result of their disability, or talk about the alleged behavior, but if statements are usually a good way to get around it. And again, that just brings us back to this point of the MDR is not to have the disciplinary hearing. It's not a secondary disciplinary hearing. The focus here is on the child's disability, the child's needs, and whether those needs are being met. Something that can help, in addition to focus the school on those questions, is to come prepared with your child's DSM diagnosis if you have it. Unfortunately, the schools don't usually have this or bring it themselves. If you come prepared with it, you can help explain to them your argument for why the behavior that they're accusing your child of is related to their disability. In addition, you should consider bringing any supports you can to help you make your argument, including out-of-school therapists or care coordinators. And it's particularly helpful to have these folks on board with this kind of, you know, expertise if you're trying to make an argument about how the child's behavior was aligned with their DSM diagnosis. And a final advocacy tip that, you know, applies in lots of situations is that a really effective way to make an argument, especially with a school district that you're worried might have already made up their mind, is to ask questions. So for example, you know, you could ask, well, if my child did not do what you're alleging, if my child did not do what you're alleging because he struggles with impulse control, then why did he or she do it? Or how is this alleged behavior not a result of my child's disability? If you make your argument in terms of questions, then the school district has to answer, and you might be able to get to the bottom of why they are really seeking to remove your child from school. And even if that doesn't convince them to keep your child in school at the MDR meeting, it could be helpful for you if later on you decide that you want to file a due process hearing to challenge the MDR decision and get your child back into their original school or educational placement. And again, you have 1 year from the MDR meeting to file that request for due process, and it will be heard on an expedited or very fast timeline compared to a normal due process hearing request. Okay, so we're going to go back, as I mentioned earlier, to the topic of alternative schools. So first we'll talk about what are alternative schools and what rights do kids have before they are sent there. So what is an alternative school? Well, what we often hear schools say is that an alternative school is a therapeutic environment and therefore can serve children with more intensive needs. But actually under state law, alternative schools are defined as what you see up on the slide, which is schools for children whose behavior is disruptive. So what this definition reflects is what we most often see in reality on the ground, that alternative schools are disciplinary and punitive placements rather than therapeutic environments. Sometimes schools will try to convince parents to voluntarily transfer a child to an alternative school due to their behaviors, or because they say the other alternative school has more protections for them or therapeutic interventions, or the school might just transfer your child involuntarily. So what's important to remember is that alternative schools are disciplinary placements under Louisiana law. They're the disciplinary placement, as Lauren talked about earlier, that children who are expelled, for example, have to attend. And there is a right under Louisiana's discipline code for all students to a notice and hearing before they are assigned to an alternative school. So that means they have due process rights. And the school can't just bypass the suspension and expulsion procedures in the Louisiana discipline statute before sending your child to an alternative school. And in addition, an MDR is going to be required where most alternative schools are more restrictive settings than the child's original placement or classroom. So it's a change in placement longer than 10 days. So you're going to have an MDR meeting. If after the MDR meeting, the school district still wants you to voluntarily transfer your child to the alternative school, what's important to know is that this is not the end of the road. You can challenge the school's MDR decision in a due process hearing, and in addition, your child still has a right to due process before transfer. What we're hearing is that some districts are not following these rules before sending kids to alternative schools. And what we see is that kids with disabilities and Black kids disproportionately are transferred to alternative schools, and they're transferred there without due process. So if your child or a child you know has experienced these problems with alternative schools in Louisiana, please let us know. We have a campaign that is ongoing around alternative schools in our state, and we would really like to speak with you. If your child is already in an alternative school, don't panic. Your child still has rights there under the IDEA, which you can enforce. So wherever your child with a disability goes, whether they're suspended or expelled or in a mainstream or alternative school, they have a right to receive a free and appropriate public education or FAPE. So they have the right to make progress towards the goals in their IEP in any setting. And you can make sure that this is happening in the alternative school environment. And if it can't be provided in the alternative school environment, seek dispute resolution options like filing a complaint. So for more resources about, what those dispute resolution options are, and just generally how to advocate for your child to make sure that they receive FAPE, you can check out SPLC's online resources. And of course, you get lots of support and trainings as well through Families Helping Families on these topics. But here's just another tool to add to your toolbox. Right now, the guide that's posted on the SPLC website is a guide to special education rights that is focused on federal law, but has some specific Mississippi laws weaved in because that's the state that the guide was originally created for. But we do have a Louisiana specific version of the guide coming out soon that will be posted at this link. But you might still find some really helpful tools, especially in the appendix of the current guide, even though it's Mississippi focused. So Appendix G to that guide on the SPLC website has some forms that you can just print or just copy on a piece of paper for yourself to help keep you organized, during an IEP team meeting. There's a fill in the blank sheet for important information during IEP team meetings, or if you're having a lot of those ghost suspensions or silent suspensions, one way, like Lauren mentioned, to start to hold the school district accountable, even if you're not comfortable, sending them an email about it or speaking with someone at the school district directly, is to keep a log of all the times that this is happening. So there's a sample log that you can use in the guide. There are also sample letters, just for basic stuff in the process of making sure that your child gets evaluated and gets through the IEP process, including some sample fill in the blank kind of forms for complaints in the event that you would need to file those. Of course, you know, we always encourage people to seek legal advice if they're considering filing a complaint. And to that end, you know, please reach out to us. This is all of our contact information, mine and Sophia's and Lauren's. And, you know, we'd love to speak with you, answer any questions you have. We'll have a few minutes for questions here, but if you have a specific question and want to do an intake to find out whether SPLC can help or whether we can refer you to another group in the community that can help, please reach out to us. We do intakes all the time, and we'd be very happy to speak with you. So with that, I think we have time for questions. I'll go ahead and stop the screen share for now.
This is Laura. Can you go back to the slide so I can scan for the guidebook?
Sure. Yep. I'll leave that one up.
Okay, thanks. Oops. Here's a question for you that I get asked all the time is, do we have to do a hearing or can we go straight to an MDR? I know they can get both, and it makes more sense to me that they go to an MDR first. But I know some districts will do hearings first and then the MDR, or some will do the MDR first and then the hearing. But I don't think I've seen anything on IDA where it says either or is first or second.
So we always argue that the MDR should come first.
Right.
And although, you know, there isn't something in the IDA that explicitly says that, if you are going to have an MDR meeting, then there's no, and the behavior is related to the child's disability, there's no need, right, for the disciplinary hearing. You know, as lawyers, we make legal arguments about how within the statute, the MDR meeting is required to come first. That is, you know, a legal argument that is not necessarily within, that is not within a non-lawyer's wheelhouse to make, but just sort of a common sense approach to it is, why would we spend our time having this suspension or expulsion hearing if you're not even going to be able to suspend or expel them for the behavior that's related to their disability? And, you know, I have had a colleague at another job that I had who, you know, they did the MDR meeting, and the behavior was determined to be the result of the child's disability. And then they wanted to have the suspension and expulsion hearing anyway. And, you know, my colleague, his attorney said, no, we're leaving. You can't, you know, suspend or expel this child for something that is the result of their disability. We are leaving the school building right now. And to be clear, you know, it's, if schools are presenting it as a choice, either you get a discipline hearing or you get an MDR. That's a problem if the child is facing exclusion more than 10 days, either all at once or cumulatively over the course of a school year. Students with disabilities have a right to both, and we always argue that the MDR should come first, and we think there's good grounds for that, you know, within the law.
Sounds good. Thanks.
Ashley, will you be sending me the PowerPoint slide deck?
Yes, I can do
Okay.
that.
Great, thanks. And I will disseminate that to all attendees. So you all will have all of this information at your fingertips.
Here's another question for you. We have a lot of alternative settings, which they are, and like you said, calling them therapeutic settings. I know therapeutic settings is completely different than what you see at the alternative schools. How do you argue that point that's not really a therapeutic setting? To me, it's all in the same. You have your social or your counselor, smaller class. There's really not much different than at a typical school. So how do you argue the fact that, what do you mean that's an alternative school? What is different? How is this going to be any different than where he's coming from, where he's at now?
Yeah, I mean, Sophia and Lauren, feel free to jump in, but you know, I think there's two pieces to advocacy around this that really apply no matter what the school is trying to do with the child in terms of where they're trying to send them, which is, you know, the first piece is, what does the child need to receive FAPE? That's the first question. What services do they need? What's in their service grid? And then what is the least restrictive environment where the student can receive those services? So, you know, the first question that I would ask in an IEP team meeting is, you know, what services are provided in whatever setting the child is trying to, the school is trying to move your child to. And what kind of staff do they have there, and what kind of credentials, and is that matching up with the service grid? And only then do you have the discussion about whether the child's being educated in the least restrictive environment. So even if the school is claiming that, you know, well, you know, the alternative school does have social workers and they have all the staff that can meet your child's needs, then the question becomes, is this the least restrictive environment? So there's, you know, an obligation under federal law to educate students with disabilities with students who do not have disabilities to the greatest extent possible and appropriate for them to continue to receive FAPE. And what we see is that these alternative school settings are in fact often very restrictive as compared with the child's current mainstream classroom, and really restrict them from interaction with non-disabled students, maybe completely, maybe they're in a completely separate building from kids who do not have disabilities and are excluded from after-school sports with those kids. I mean, it can be very separate and unequal. So I would look at first, you know, kind of interrogate whether that environment they're proposing at the alternative school is going to provide FAPE, and second, whether it's the least restrictive environment. And it is a change in school placement. So if the school says, you know, we disagree with you, we think that this alternative educational setting is going to provide FAPE, and that, you know, either it's not more restrictive, or it is more restrictive, but your child requires that, and we're calling this some kind of, you know, substantially separate setting or something in their IEP. It is a change in placement, and you as a parent have a right to assert stay put rights to your child's current educational placement, and to reject that change in placement. And those stay put rights to the current placement stay in effect, so your child stays in their current educational placement as long as you know, the due process proceedings are pending.
Thank you.
And I know my name is Alicia Valiant. I was formerly an educator, now work for the Governor's Office of Disability Affairs. In some districts at the alternative schools, the students have to take, and When I say some, I mean some. I can't speak for all over the parish, all over the state. The students have to take social emotional classes in the alternative setting. So maybe that's what they're talking about with the therapeutic environment.
Yeah,
Not
absolutely.
necessarily. It's just basically saying that they'll get more of the attention, but there's nothing therapeutic about it. I mean, I don't see any different credentials than in the typical brick and mortar school.
Oh, okay. Well, what I was speaking of was a school psychologist would go in and do, I think it was 30 minutes of social emotional classes at the alternative setting.
Mm.
Yeah, I mean, I think one question with that is why can that service not be provided in the mainstream school environment so that the student can be educated in the least restrictive environment? And that goes back to that, that first piece of one, what's going to provide FAPE, and two, what is the least restrictive environment? Is this child being appropriately integrated into an environment with non-disabled students to the greatest extent possible?
When I think of therapeutic, I think of the resilience in New Orleans. I think of that setting. That to me is therapeutic. But what they offer in the alternative school, I don't see how that's any different than a brick and mortar or their particular school, that they can be provided at their school versus an alternative. So that's always been my argument.
A lot of times this is Melinda from Families Helping Families of Southwest Louisiana. A lot of times they'll tell us that there's a higher student to staff ratio. Well, one of the grandsons is in a regular school in a 2 staff to 2 student classroom. It doesn't have to be at the alternative school or the therapeutic school or whatever they're calling it today.
Absolutely. Mhm.
Any other questions or comments that you guys have? I have really enjoyed this presentation, ladies. Thank you so much for being with us today. A lot of great information, and I'm looking forward to having the slide deck too, to have those things so that I can refer back.
Oh, thank you for having us, and thanks everyone for attending. And like we said, please feel free to reach out to us. We'd love to be a resource to Families Helping Families and the important work that you all do.
Also, I have dropped the link for the evaluation in the chat box. If everyone wouldn't mind just clicking on that for me and catching that real quick, I would appreciate it. I'm going to stop the recording